Taking a live look right now at the Supreme Court as oral arguments are underway on two major affirmative action cases. The outcome could potentially end race-based college admissions. The High Court specifically looking at the admissions process at Harvard University and the University of North Carolina. Challengers in the case argue both universities' programs violate equal protection principles and discriminate against Asian Americans. National correspondent Logan Raddick joins us now live from Capitol Hill with details. Logan?
Emma, good morning. In both Harvard and the University of North Carolina, they are being alleged to offer specific preferences to applicants of certain ethnic backgrounds. That is the argument you're hearing from the plaintiffs at the Supreme Court today, specifically saying that they're discriminating against Asian American and white American applicants through this affirmative action process. Now, this is an issue that is really reaching a boiling point in the country in terms of the discussion, about higher education in general. A new Washington Post poll finds that 63% of U.S. adults support the Supreme Court banning colleges from considering a student's race when making admissions decisions. However, 64% also say that programs designed to increase racial diversity are a good thing, just not when it comes to the admissions process. Now, challengers in the cases before the Supreme Court, they're arguing that Harvard and North Carolina are violating equal protection principles and discriminate against Asian Americans. At those universities, race is used as a, quote, plus factor for admission criteria. And a conservative group called Students for Fair Admissions is behind both of these challenges, and the group's composition includes several former law clerks for Supreme Court Justice Clarence Thomas, who himself is critical of affirmative action. Now, the named plaintiffs are white and Asian students who say they've been discriminated against both at Harvard and North Carolina, the schools that allegedly prefer applications from Black and Hispanic students. Now, the challenges at hand, they're particularly focusing on Asian American students and a charge that those universities are discriminating against another minority, while Harvard is a private university and it's still subject to Title IX because it receives public funds. Now, one of the few Harvard alums on the Supreme Court is Justice Ketanji Brown Jackson. She's making it clear where she stands on this issue. She supports affirmative action in higher education admissions. However, she is recusing herself from the Harvard case, considering the fact that she did once serve on a Harvard board. So right now, the arguments are underway in both of these cases. They're starting with North Carolina and then moving on to Harvard, and we'll see what the court rules. But it seems that the three liberal justices will all support affirmative action in the admissions process. Now, the question is, how will the conservatives rule on this, especially the Chief Justice, John Roberts, who is really a swing vote on the Supreme Court?
All right, Logan Raddick there with the latest on that, joining us live there. Logan, we appreciate that from the Capitol. Here with reaction now, some bright legal minds here. Joe DeGenova and Victoria Tunzing joining us live. Good to see both of you here. Thanks so much for coming on. So you've heard Logan's report. I know you've been following this affirmative action cases, two of them playing out there, Harvard, UNC. What do you believe will actually happen here, in keeping in mind that 10 states have actually banned the use of race in public university admissions? What are your thoughts here?
Well, I think it's pretty clear that the court is going to overturn the precedents that say universities can use race as a factor. I think they're going to overturn those cases. 19 years ago, Sandra Day O'Connor said, in 25 years, we should stop using affirmative action because we will have solved the problem by then. In fact, Ketanji Brown Jackson says we should never stop using racial preferences. She says that this type of remedy, affirmative action, must always remain a part of the 14th Amendment. Remember, affirmative action is not in the 14th Amendment. It was a remedy created by the Supreme Court to deal with what it saw as disparate treatment over years. Those days are over, and I think we're either going to get a 6-3 or a 5-4 vote to overturn these racial preferences in university admissions.
And this, too, Victoria, I'll show this to you. This is an opinion piece because there are obviously two sides, right? So here's the Washington Post editorial board writing part of it, quote, affirmative action is a fraught issue on which people of goodwill disagree, but the court has already been far too aggressive in overturning major precedents merely because its membership, not reality, has seen dramatic shifts. The justices should resist doing so again, end quote. That from the Post.
A great legal scholar writer in the editorial board of the Washington Post, who is wrong about every single day. I read it so Joe doesn't have to. An interesting thing about this case is Harvard is a private school and North Carolina is a public school. And so the rationale is really the same for both cases. It's just that they're based on, one's on the Constitution and one's on a statutory provision. But Justice Jackson has recused herself only from the Harvard case, but the thinking is going to be the same for both cases. So it doesn't make sense to me why she didn't be really honest and recuse herself from both cases. And by the way, Clarence Thomas, and he said this repeatedly, he opposes affirmative action because when he was at Yale, everybody thought he was there only because he was an affirmative action person, that he really didn't deserve to be there. So he has suffered the inhumanity, the humiliation of being looked at as an affirmative action person when in fact he wasn't. He's a brilliant legal scholar.
We'll continue to follow it. Major cases coming out of the High Court